Good afternoon, everybody, and welcome to today's webinar. So what are we going to talk about today? We're going to talk about the EU's fine on X for failing to respect EU law. We're delighted to invite Laureline Lemoine from the law consultancy AWO to unpack some of the details and to spread some clarity about what is really happening. For those of you visiting us for the first time, EU Disinfo Lab is a non-profit organization gathering knowledge and expertise on disinformation in Europe. This webinar is the first of a new series entitled Evidence and Enforcement. This series shifts the focus from rules to results, exploring how evidence gathered by researchers and civil society feeds into enforcement action and what meaningful accountability requires in practice. We're launching the series today, and another is scheduled for the 9th of April on civil society evidence under the DSA, lessons from AI forensics with Mark Fadul. A big thank you to all of you who have made proposals for this year's conference, Disinfo 2026. We received 350 proposals. We're looking forward to opening registrations in early May with tickets and pricing to be published shortly. The main conference takes place on the 7th and 8th of October in Vilnius. So before we get underway, I have some housekeeping rules. Firstly, to note that this webinar is being recorded and being uploaded to our YouTube channel and website, so it can be watched later. Captions and translation are available if needed. You should, if you need to follow our discussion in your own language, click on CC on the bottom left of your Zoom window, enable the translation option, and choose your desired language. An important note, for our questions and answers, we use Slido and not the Zoom chat. To use Slido, you scan the QR code, which should be on your screen, or go to slido.com and enter the code #disinfo. I encourage everyone to connect already to Slido, and you can submit questions at any time during the presentation. To start with, we have 2 polls on Slido and encourage participants to submit responses immediately. The questions are: where are you joining us from, and which sector do you represent? We've got a growing number of locations, with Brussels winning at the moment. So before to start, we now launch the discussion with Laureline, who will give us a breakdown into our insights about the EU's fine on X. And over to you, Laureline.
Thank you, Joe, and thank you for having me. I'm going to share my screen. Right. Is that working out for everyone? You can see my screen?
Yes.
Great, thank you. All right. So just a quick word about AWO. We're a law firm and a consultancy specialized in digital rights. We've been working on a DSA for over 5 years now, with a range of stakeholders, including the Commission, the Fundamental Rights Agency, and civil society organizations. We worked on content moderation, online advertising, freedom of expression, generative AI, and access to data. And so today I will present and analyze the European Commission's first non-compliance decision under the DSA. And this decision marks really a significant step in the EU's evolving approach to platform regulation and enforcement. Finally, we see the Commission begins to move from supervision to formal findings of non-compliance, and fine. So the decision really provides an important signal to online platforms, but also regulators and civil society about how the DSA obligations will be interpreted and applied in practice. And so in this webinar, we'll look at the Commission's reasoning, we'll look at the legal and procedural implication of the decision, and what it tells us about the future direction of DSA enforcement. We'll begin with some context, including the broader enforcement timeline, before moving to a detailed explanation of the infringements. Then I will highlight a number of additional issues that I thought were particularly interesting. And finally, we'll look at what comes next, both procedurally and also in terms of broader implications and practical takeaways. So just to flag, the decision is actually quite long. There's many things to say about it. So I won't be able to cover everything, but hopefully it will give you a good overview and a better understanding of the decision. So let's start with the broader context. The enforcement of the DSA by the Commission is taking place in a politicized environment. In the US, there's been a lot of debate and reports about online speech and platform regulation, and the DSA has been a focal point of criticism among US policymakers and public commentators. Several US figures have argued that the DSA leads to censorship and restrictions of freedom of expression, which the European institution and some member states have consistently rejected. But nevertheless, this is the first concrete enforcement measure and it's unfolding against this backdrop of political tension. On the 5th of December 2025, the Commission announced that X had been fined 120 million euro for breaching the DSA. And on 23 December, US Secretary of State Marco Rubio announced visa restrictions targeting 4 members of civil society organization and a former European commissioner who oversaw the drafting of the DSA, accusing them of being agents of the global censorship industrial complex. Then the controversy intensified further a bit, and on 20th January, the US House Committee on the Judiciary published the full Commission decision imposing the fine on X after it subpoenaed it from X or Elon Musk. And by making this document public, the committee really wanted to demonstrate that the DSA censors American speech and innovation. And we'll see in a moment that it's not really the case. This is not what this is about. But in any case, we also had on 3 February this year, the same committee released an interim report on Europe's supposed campaign against American speech and how the DSA and the fine against X is really the culmination of this effort. And the report contained thousands of pages of internal email that were subpoenaed from online platforms. And while platform employees' names were removed, staff from civil society organizations and the Commission were left fully named. And of course, I see this as a bit ironic because we are able today to analyze this decision because it was leaked by the US Judiciary Committee. The decision still hasn't been published by the Commission. The Commission said they will do it as they publish all formal enforcement decisions. There's also an obligation in the DSA to publish the non-compliance decisions. Although it's quite interesting to note that they're not required to publish the whole decision. Article 80 DSA only requires the Commission's publication to state the name of the parties, the main content of the decision, and the penalties imposed. But also, Article 80 also imposes an obligation on the Commission to have regard to the rights and the legitimate interests of the platform concerned by the decision, but also any other person or third party that is involved in the protection of their confidential information. So we can only guess that the Commission still has not resolved those issues yet, be it with X or with the other parties involved. And we've seen that in the decision published by the Judiciary Committee, there's really minimal redaction. It mainly concerns X corporate structure and finance, also information on access to data applications. And there doesn't seem to be any specific consideration for the personal and confidential information of the third parties mentioned in the decision. So this is the broader context, but now let's look at the timeline quickly. So X was designated as a VLOP in April 2023, and 8 months after the designation, the Commission had already opened formal proceedings against the company for multiple suspected infringements. Then we see the investigation then takes about 6-7 months, and the Commission publishes its preliminary findings of non-compliance around mid-July of 2024. And this is for failure to comply with 3 specific provisions. Now, X has now access to the file and all of the evidence, and so they reply to the findings at the end of September. But then, from then, we don't really know. There's not much going on externally, of course. There's only one RFI, the request for information, that is sent, but it's about the corporate changes of X. So the Commission was probably working internally or with third parties. Of course, there was also discussions that, in the EU bubble about whether the decision was ready, but was actually delayed politically, but we can only speculate on that. So 2025 is rather quiet. Then at the end of November, X has a new legal team and they want access to the file again. But the Commission says no, and then the day after, they publish the non-compliance decision. And in this decision, the Commission concluded that X failed to comply with 3 specific obligations under the DSA. So in this next part, we'll take a closer look at each of these obligations and the Commission's reasoning. All right, so first, infringement. This is about infringements of Article 25(1), which deals with online interface design and organization. So here we're talking about the blue check mark. In recent years, X significantly changed how its verification system works. So the well-known blue check mark on Twitter once indicated that the platform had verified the identity of notable public figures, journalists, and organizations. And now it's primarily tied to a paid subscription called X Premium. And under this new system, users can obtain the blue badge by subscribing and meeting basic account requirements rather than being selected based on public notability. So the Commission basically found that the visual and the textual design of X online interface in relation to account subscribed to X Premium services, as well as the manner in which the interface of X is organized and operated, well, all of this basically deceives users into believing that accounts with a verified status are meaningfully vetted by X. So it distorts or it impairs their ability to make free and informed decisions regarding the authenticity and reliability of those accounts. So that's the infringement of Article 25(1). And the arguments of the Commission are that there was a misappropriation of the historical meaning of the verification check mark. So as I said, it's like keeping Twitter's legacy design, but changing the verification process and making it less rigorous. There's also a misappropriation of the meaning of cross-industry standards. So that's interesting here because the Commission relied on this comparison of cross-industry interface design and eligibility criteria for account verification. And they showed that X really departed from the shared system of identity verification towards a system of anonymous paying subscribers. There's also an artificial algorithmic amplification going on. So the whole system of paying for reach and for higher visibility. But the whole issue is that users are not being informed. In the reply feed of the platform, users only see the blue historical blue check marks, and historically also verified accounts were organically more visible to users due to their public standing. And now it's not linked to engagement metrics anymore. Also, the commission noted that X was very much aware of the deceptive nature of this new verified status. Um, for this, they relied on an NPR investigation into the internal risk assessment made by X before they made the change. And in this internal report, the deceptive nature is acknowledged. And so we see that X really chose to ignore expert advice and they refused to remedy the situation. The commission also interviewed a former Twitter employee on this question. And as I said, this is like insufficient and ineffective information on the meaning of the verified status. So users, they don't really know what it means. There's no information on the timeline display. And also to prove this, they also looked at, where is the information on X? And they looked at the Learn More page, and it was 3 clicks away, a pop-up window, a separate help page. So really complicated for the users to find what the changes that were made to the system. And also we have the risk of adversarial abuse of the new status. The commission said there was lots of evidence that motivated, malicious, or fraudulent actors benefit from the deceptive nature of X verified status. So they mentioned a study, the same study actually throughout the whole analysis, that was talking about cryptocurrency accounts. Also, experts were interviewed about how the status could be a vector for financial crime and financial fraud. They used an article by a famous cybersecurity firm, studies from the OSINT community, and they used the example of the Donald Duck account, which is protected IP. And the last argument was the financial incentives and how X actually benefits from the deceptive nature of the interface. And so for this, X was fined 45 million for this infringement. So that was the first one. Then we have the second one, which is Article 39. So this provision under the DSA requires very large online platforms to create and share this public ad repository in a dedicated section of their interface. The ad repository must be searchable, reliable. It must allow users to filter information using multiple criteria, and it must be accessible through application programming interface. It must also contain like a list of information that's in Article 39.2, like the content of the ad, the brand, who paid for it, the number of users reached, etc. And all the advertisement must remain available in the repository for as long as they're shown on the platforms, plus 1 year afterwards. And basically, the Commission argues that X infringed this provision because the ad repository is not available through a searchable tool. It does not allow for multi-criteria queries. You can see like a screenshot of the repository below. There's also not even all the information that they're supposed to publish is there. And the evidence that they use is simple trial interactions with the repository. So the Commission using the tool and saying like, oh, we can only choose one member state. We can't even search based on the content or the person who paid for it. They also had experts who corroborated these limitations and also showing how these limitations really frustrate the purpose of having an ad repository. The Commission also interviewed civil society organizations and they quoted multiple reports and studies. Again, they did this comparison with other platforms and to show really that the limitations were unnecessary and intentional. They also found that it was not reliable. Again, kind of the same arguments. Also, the ads don't stay until 1 year after they were presented. One other issue is that the platforms are supposed to publish information on commercial communications, which is communications that are declared as such by the users. So it could be like influencer marketing, for example. And on X, the only way to retrieve that information is to download this huge CSV file with millions of entries. And the commission even said like the file is even too large to be opened with conventional tools. And another argument was that the ad repository is not available through API. The API does not provide, anything else compared to the search tool. There's multiple error issues. It was previously only available for paid subscribers, and all the malfunctions are not being addressed by X. So X was fined 35 million euro for this infringement. And the last infringement is infringement of Article 4012. So under this provision, VLOPs have to give access to publicly accessible data, including real-time data, if possible, to researchers who comply with some conditions and who only use the data to perform research on systemic risk in the EU. And so what happened is that when the DSA started applying, X dismantled Twitter's academic API program without providing any alternative. They just started charging people to gain access to data, which the commission said it's actually not compliant with Article 4012. And X, they claim that they provided this like free alternative, which was this obscure email address that X did not communicate about and was very generic. So X at some point introduced changes, but the commission was still not convinced because the first argument that they have was that X had an overly restrictive interpretation of the eligibility requirements. So X had this very restrictive approach of what it means for researchers to use the data only to research the systemic risk in the EU. They would reject application based on this, but they would not provide any detail. They also had a very restrictive approach based on the geographic location of the researchers. They would systematically reject researchers on the sole basis that they were established outside of the EU, which again, Article 4012 does not allow for such a restriction. X was also asking disproportionate information on the disclosure of fundings. And anyway, this whole restrictive interpretation meant that as of May 2024, 95% of the applications were rejected. And one of the main issues is that X only sends generic rejection emails, no details on why exactly the applications were rejected. X would also often like not monitor replies. So researchers could not interact with X to understand what happened. And there was also insufficient data access quotas and durations. So if your application was accepted, it was 6 months for everyone. Does not matter about the projects. Everybody got 6 months. And access quotas, the access was insufficient in terms of rate limits. So the commission said, it was inferior by a magnitude of 10 to the previous program. So researchers were really not happy about this. And the commission noted the discouraging effect that it all had on researchers. They interviewed many researchers, everybody had the same experience. Many also did not even want to try because they knew they would waste time and resource on this. And finally, the commission took the view that as part of their obligation to give access to data, platforms they cannot prevent researchers from accessing the data, including by prohibiting data scraping. The commission noted that independent access technique, including automated technique like scraping and crawling, those techniques are very crucial to researchers to perform like the type of research on systemic risk. And the commission also had a quite broad understanding actually of what can be the subject of research under Article 4012. So that's also good news. And the commission supported its finding by using applications and complaints from researchers. They had lots of exchanges with the researchers. They interviewed more than 15 of them. They were also doing this extensive review of X internal documents and publicly available evidence. And so for this infringement, X was fined 40 million euro. And so that's it for the infringement. Now let's take a look at some interesting other issues. Um, so actually, the first question that is answered in the decision is who is the provider of X in the EU? I'll go over it quickly, but it's just interesting to see the approach of the Commission. It's all linked to kind of the recent changes, the corporate changes of X that happened recently, and that can be a bit confusing. Also, most information is redacted from the decision that was published. But when the Commission published the preliminary findings, so in July 2024, they also extended the formal proceedings. They extended the scope of the investigation to Elon Musk and to all of the legal entities that are directly or indirectly controlled by him. X obviously disputed this. They claimed that only TIUC, which is Twitter International Unlimited Company, this was the only company designated as a VLOP. So there's multiple back and forth on this issue, asking who controls what. And the Commission's main argument is that the DSA has this very functional approach that is similar to competition law. And the conclusion is that given Elon Musk's decisive influence over the relevant entities, the provider of X in the EU is actually composed of TIUC, but also X Holding Corporation, X.AI, and Elon Musk. And this is actually important for the calculation of the fine, which we're going to look at right now. So under Article 74 of the DSA, fines may be imposed on a VLOP that is intentionally or negligently infringing the regulation. And in the Commission's view, X acted intentionally or at least very negligently because it is a large and experienced entity capable of seeking legal advice. And nonetheless, X took conscious decisions to adopt measures that did not comply with its DSA obligation. And when determining the appropriate amount of the fine to be imposed, the Commission relied on, by analogy, on this well-established methodology in the field of competition law again. This is where, for example, we get the criteria of seriousness. And here the Commission considered that the infringement of Article 25 is particularly serious because it deceives users, it is an express prohibition in the DSA, and it causes direct harm to users. The other infringements are considered at least serious as they only undermined the effectiveness of the DSA. Then for the gravity, so for all three infringements, the Commission looked at the number of users. And so the gravity is increased by the widespread use of X in the EU. The infringements have a serious impact on a large number of users in the EU. The Commission also looked at the deterrent effects of fines, the size and financial capacity of the whole economic unit, so the one that we just mentioned. And they concluded that the three infringements were of a serious gravity. Then the Commission looked at the duration of the infringement, which is considered to be at least 27 months, and it's referred to as medium duration. There was no aggravating circumstances in this case, but there was a mitigating factor, which is the novelty of the DSA, because this is the first non-compliance decision. So the Commission took that into account. Now, we know that the Commission can impose a fine of up to 6% of the annual turnover. But here we have an issue because X never provided the information on the total annual turnover of the whole economic unit that we just discussed. Despite the Commission asking for it, X also never shared the annual turnover of X.AI. And the companies are not public, so the information is also not available. So what did the Commission do? Well, basically, they looked at the turnover of X holdings, and they guessed that the turnover of the whole economic unit must be far above the number that they had. They acknowledge, though, that none of the individual fines surpasses 6% of the turnover of X holdings. They even said that the total amount of the fines does not exceed 6% of X holdings. And they say that to show that it's a very proportionate fine, but it also means that it's quite a low fine because this is only based on X holdings, not the whole economic unit. But it also means that there's room for higher fines. I'm actually going to skip this one, but we can talk about it during the Q&A if you're interested. And so we're going to look at what's next. So after that decision, what's next? So first, we know that X appealed the decision in front of the General Court of the EU on 16 February. Cases in front of the court take about 20 months on average to be judged. So it's quite unlikely that we will see some movement on that side this year. Maybe a hearing at the end of the year. It's hard to know. Also, the appeal has not been published, so we don't know on which ground X is challenging that decision. But X has some deadlines to meet, some of which have already passed, actually. These dates they're based on my own calculation, so they might not be correct, and it also depends on the date of notification of the decision, which I'm not aware of. I base my calculation on the date of publication, but at least you have an idea of the timeline. So around the 2nd of March, X was supposed to have told the Commission which measures it will put in place to remedy the infringement of Article 25.1. There's a difference between the procedures for the different infringements because for Article 39 and 4012, the Commission must use what is called the enhanced supervision. And this is because those provisions are in Section 5 of Chapter 3 for the obligation for the VLOP. So it means that the board intervenes and there's this longer procedures. But so around March 5th or 9th, X was supposed to have paid the fine. So as of today, X was supposed to have paid the fine to the Commission. A quick word on this, even though X challenged the decision, they still need to provisionally pay the amounts on the Commission's bank account, or at least they need to lodge a financial guarantee, which cover the claims plus interest. And if the fine is later reduced or annulled, the EU, of course, will repay the amount. And only after the exhaustion of all the legal remedies, the amount can be entered into the EU budget. So then around mid-April, X will have to put an end to its infringement of Article 25.1. It must also send out the action plan where it will set out the measures that it intends to put in place to remedy the infringement of the other provisions. And 1 month later, the board will submit its opinion on the action plan. And another month later, the Commission will have to decide what it thinks of the plan. Is it a good plan? Will the measures be enough to remedy the infringement? If the Commission is happy about the plan, then they have to set this reasonable period for the implementation of the plan. And we saw that the Commission interpreted reasonable period as being 90 days when it came to the drafting of the plan. So maybe we can assume that if the plan is good, the Commission will monitor the implementation during the summer at least. But now maybe a very reasonable and legitimate question to ask when it comes to X, what if X does not comply? What happens? So first, in the decision, the Commission mentioned its powers to impose periodic penalty payments of up to 5% of X's daily income. So X would need to pay a fine for every day that does not comply. So if X doesn't stop the infringements, if X doesn't provide an action plan, if the action plan is not enough, if the implementation is not enough. So the Commission has this power. And if X still does not pay, so they don't pay the fine, they don't pay the periodic penalty payments, then actually the decisions of the Commission on this, so the fines and the periodic penalty payments, those are enforceable by the member states. So in this case, because X is based in Ireland, the Irish authorities can enforce the decision themselves, and they can even seize assets if needed, depending on their national civil procedure rules. So I would say the only way for X not to pay would be to move all of its assets outside of the EU. So that's good news, but what if X pays, but the infringement persists? Then, well, the Commission can issue another non-compliance decision, this time with a higher fine, because there would be an aggravating factor. And the Commission also mentioned in the decision the possibility of requesting access restriction. So the US Judiciary Committee highlighted this when they published the decision on X. But I don't think that they can realistically and successfully use this power because this is like a last resort enforcement measure. The Commission needs to ask the local DSC, so the Irish DSC, Digital Services Coordinator, to exercise its power under the DSA. The Irish DSC must then go to X's management body, and if that doesn't work, they can ask the competent judicial authority to order a temporary restriction of access. So a judge would issue such order, but there's a big but because the infringement must actually for the order to be issued, the infringement must involve a criminal offense posing a threat to the life or safety of person. And I think we can all agree that the infringement in these decisions would not really fit into that category. So I think that sadly X cannot be banned for those infringements. But let's finally look at a couple of takeaways from this decision. And to talk about this, I'm going to rely on X's main arguments against the finding, which is that there was no guidance from the Commission, lack of legal clarity, and evidence was insufficient or misconstrued. And so first on lack of guidance and legal clarity. So X claimed that the DSA provisions are not clear enough. The Commission didn't issue guidance or guidelines. So X really did what they could, and it's not fair to say that they're not compliant. And here we have a very interesting response for the Commission that says that all those provisions are actually self-executing provisions, so they can be invoked without the need for further implementing measures. And so the Commission is not obliged to issue guidelines for their application. The Commission has the power to do so, but it's a discretionary power, and the exercise of this power does not limit or delay the direct applicability of the DSA. And this is quite important to note because the absence of guidelines does not prevent individuals, companies, or national authorities from relying on these provisions and asserting rights and obligations under the DSA. Arguably, not all provisions of the DSA are self-executing, so they're not all clear enough to have direct effect. But we also see that, and this is my second point, that the first DSA case presents relatively easy, straightforward infringement. Because again, these provisions are self-executing and clear enough so that the violations are also clear on their face. They can be factually well documented. They're legally unambiguous. And so when we come to this argument of evidence and evidence thresholds, what is enough to prove an infringement, then with these provisions, we see that the Commission faces a lower burden of proof. And because it does not need to rely on some kind of novel interpretations or complex technical assessment. They can point to direct observable non-compliance. And this is what the Commission says in response to X, They say this is a straightforward infringement, so we cannot be subject to disproportionate burden of proof. They also explain in terms of thresholds that the evidentiary benchmark is tailored to the specifics of each case. Um, and so the requirements for proof are proportionate to the nature and the gravity of the infringement. They also said that evidence should be assessed based on the methodological soundness and the factual relevance to interpreting and applying the provision of the DSA. So this is how they decide which study or reports to rely on as evidence. And so for those kind of cases, third parties like researchers of civil society organizations can really help the commission because proof of non-compliance can be easily documented without having um, investigatory powers like a regulator would, or without access to confidential information. And we have seen how the Commission actually uses civil society reports and complaint interviews. They use all of this as evidence in this case. So maybe this can be my final word. DSA can work and we can help. Now, let's see what happens, what the court will say, and what other decisions will be issued by the commission, especially when it comes to more complex assessment and provision. But thank you so much. I hope this was helpful.
Thank you very much, Laureline. There are several questions in the queue. So we'll jump straight in so we can get the most out of our time. If I can group the first two questions together, do you think that any failure in the court would damage the DSA even before it gets started? And linked to that, is there any way civil society groups could improve the legal admissibility of their research so that it can stand up and help enforce the DSA?
Thank you. For the first question, I don't think it will weaken it. It depends, it depends what the court says, what are the arguments of the court? Is it based on the methodology? Is it based on the different interpretation of the DSA? There's many different arguments that the court could have. And I think it's actually useful for the commission to know because this is a novel text, so the commission also needs guidelines. And if they have more clarity on how to conduct investigations, how to maybe calculate the fines, that's also useful for the commission. So I would not say that it would weaken the DSS power. It all depends. And I think the commission has been very careful because this is the first case. So they made sure that they have enough evidence and that they respected all the procedures. So let's see. But again, it depends. Maybe the court will say something completely different to the interpretation of the commission. But I think it's also the commission's role to not let that decision weaken the DSA, but actually use it to enforce the DSA in a better way. And then for the second question, I think this is what I just said actually to the way to improve the legal admissibility of research. It's making sure that the methodology is very it's sound and it's useful for the commission. It's useful for the interpretation of the DSA, and yeah, there's not a lot like as I said. It all depends on which infringement. So the commission will have a different threshold. But I think if your study is good, good methodology, then the commission will use it. Of course, the platforms will always find something that is wrong with the methodology. They would say, it's too small, but I think just do your research in a sound way, and then it should be fine. But you can always also try to talk with the commission to see maybe what they're looking for, and where is the gap in the interpretation or in the evidence, maybe.
Thank you, Laureline. Attached to that, there is a question on um, the role of NGOs in triggering or shaping enforcement, and if there are, and what are the limitations in to that influence.
That's a good question. It's hard to know when you're not in the commission, um, but I think it's the decision of the commission to pursue certain types of infringements, and so even though civil society might have a lot of evidence about a certain type of infringement, maybe the commission, politically or for other reasons, might not want to pursue this. So this is one of the limits, is that ultimately the commission will decide what they want to go after. Um, but then, the civil society organizations can also formulate complaints to try to force the regulators to look in some direction. But ultimately, it's up to the regulators in any case. They have the last words, sadly. But also, we've seen that civil society can also go to court themselves. We've seen that in the Netherlands and in Germany with really good results. So this is also maybe one way to help the enforcement of the DSA.
Thank you. I think the last point is important on the Netherlands, and we're planning a webinar in May with Bits of Freedom about the Dutch case. So more to follow on that. um, it's a question about the limitations of access to data with regards to community notes. Was that raised in this case so far?
No, this was not about, I don't think, no, this was not about the community notes. So there was no information on this. It was more data access in general. And also all of the applications, the data access applications were all redacted. So we don't know what was the purpose of the data access, but the community notes were not mentioned in the decisions. This was not about this. I know it's subject of another investigation, but for now, this was not about this.
And a question that I personally have some insight into because I was in the negotiations at the time. When the DSA refers to a reasonable fee for data access, is there any clarity as regards what reasonable might mean?
No, because I believe this is not the same provision. So I think this is about for Article 44, like this is about the proper data access and regime. And here the decision is about 4012, so it's the publicly accessible data. So it's another procedure that needs to be free. So it's different. So there's no more information about this, sadly. This is a different issue.
Okay, and a provocative question: whether, with all of the noise around DSA enforcement, um, is are we leaning more towards geopolitical signaling rather than consistent application of the law?
That's a good question, but I would say I read the decision multiple times, and it is a sound interpretation. It's quite strong. So I think there's really good work being done by the European Commission. But then, of course, it has become very political. So it might be a political decision choosing how to enforce the DSA. Sadly, like this is inevitable. And I think maybe the commission is waiting to see how the court is responding to their legal reasoning. But I think if they the commission shouldn't be too political, but it is. So like, there's not much we can do about it, sadly. I wish it was not about just geopolitical signaling, but you know, we'll see. We'll see if hopefully there will be other non-compliance decisions to show that, this is about compliance with the law, but who knows?
Um, Related to that and to your previous response um, on Germany and the Netherlands, do you think that the future of enforcement might lie with mass representative actions um, on a member state level rather than waiting for the Commission to issue administrative fines? Or is it an undefined mixture of both that we can expect?
Well, I think we should explore all of the avenues, but it's very empowering for users to also go to court yes, as I said, like if the commission is not doing its job as guardian of the treaty, as enforcer of the DSA, this is a good option also to show that users have power, that they have the will to apply the law as well. Um, then we need to see like, how the courts respond to this. It's also very costly for users or civil society organizations. Um, so a mix of both would be the best. But yeah.
Um, there's a question asking for a further explanation of the 60 and 90-day terms and when it started. Can you?
Um, yes, I can explain. So it was 60 and 90 working days. So I just counted from the 5th of December and I did not count the weekends and the holidays. I did that very quickly, so like this is maybe not correct. But there was a difference between like the ex had to pay the fine, 3 months after they were notified. So 3 months for me was different than saying 90 working days. So I just calculated like this, but maybe this is not correct. But we haven't had any information from the commission. Um, so maybe we'll learn later that X paid the fine or like they'll communicate on the action plan. I'm not really sure. This is the first time that they're doing this. Uh, so yeah, let's see. And sorry if this is not really correct. But I started on 5 December, the publication date, even though I know it's supposed to count from the notification date. But we don't really know when that was.
Okay, thank you. The next question seems to be more of a statement than a question, I think. So, skipping to the next one, um, could you explain in on Article 25 whether the Commission found actual evidence of malicious acts, or did they just address Article 25 on the basis of potential harm?
I think I remember that the commission used studies and articles that were like looking at specific accounts that were doing like cryptocurrency accounts or like financial fraud. So it was all public evidence. But of course, in the decisions, we don't have access to all of the evidence. Like they just mention some studies or they say that they have evidence, but only X had access to the evidence that was used by the commission. So I'm not so sure, but it sounded like they actually had evidence, not that they found themselves, but that other third parties found. Yes.
Okay, there's a specific question about the Hungarian data access issue. That's on the edges of the topic. If you've got any comments, you can volunteer them.
I do not, I'm sorry. I'm not so sure which case you refer to. Um, but I'll be curious to look into it.
Again, and the final question, as we're running out of time, a provocative question on whether any aspects of the decision looked less or shaky or questionable in your view.
Not really. I thought that there was good legal reasoning, and again, it was very factual. And I agree with the commission. It was very straightforward infringement. What I found was a bit like shaky or questionable was X's arguments and really the bad faith arguments that they had. Sometimes the blatant um, misunderstanding of the DSA, which for me was a bit sometimes ridiculous because it's supposed to be, X is represented by lawyers. But so this was really bad on X's side. X's defense, I thought was really bad. The commission thought was very thorough in their analysis and legal reasoning. I think a bit too much sometimes, but this is good. So, and again, I think this was, as I said, easy with the easy case. And I'm looking forward to the decisions on more complex provision, like the risk assessment provisions, for example, where here there might be a bit more interesting and different interpretations that people can have. But for those infringement, I think it's pretty straightforward, so not much to say.
Fantastic. Thank you very much, Laureline. As we're coming to the end of a very packed hour of really interesting analysis, I have a few final housekeeping points to make. So thanks again to Laureline, and thank you to all of the attendees and the very helpful and insightful questions that they asked. As I mentioned at the beginning, the evidence and enforcement series started with this webinar. On the 9th of April, we have another webinar on civil society evidence under the DSA, lessons from AI forensics with Mark Fadul. Other some webinars that we have coming up are AI generated content and DSA enforcement, who is accountable, with Marco Bassini from Tilburg University. We have a webinar on how civil society can defend itself, the EDRN pilot story, with Ines Narcisco and Tanner Wagner. To remind you that there's a recording of this webinar available on our YouTube channel and our website shortly. When you exit this webinar, you will have the option to fill out a feedback questionnaire, giving you the opportunity to rate the webinar and also to suggest future topics. We very much welcome any input that you have. And on that note, I wish you a great afternoon and see you for the next webinars.
Thank
Cheerio.
you.
Bye-bye.
Thank you. Bye.